Hello everyone, I, Tisha from Corporate Law Journal, welcome you all to this channel. As you all know, the purpose of this initiative is to explore corporate literacy and to impart legal education in a simple and lucid manner. Today, we are going to discuss the Companies Amendment Act 2020. Before starting to this session, I would request you all to please subscribe to the channel and press the bell icon for more updates on corporate and commercial laws. August 2013, the then President of India gave his assent to the Companies Act 2013 passed by the Parliament, which later came into effect on 1st April 2014. With its enactment, it aimed at easing the process of doing business in India and improving corporate governance by making companies more accountable. It came with significant concepts such as one-person company, small company, dormant company, and corporate social responsibility, along with some changes in the provisions related to governance, e-management, compliance and enforcement, disclosure norms, auditors, mergers, and much more. The Companies Act 2013 replaced the old Companies Act 1956, which, although amended approximately 25 times, was still considered to be out of date and inadequate compared to the legislation regulating companies in many other jurisdictions. This act was a positive step towards modernizing India's company law and aligning it to global standards. It gave increased decision-making powers to the company and introduced provisions giving minority shareholders additional rights and protections. Since the enactment of the said Act, there have been many national and international changes in the economic environment which have made the economy more diverse, complex and dynamic. Therefore, consequently, the 2013 Act has also gone through considerable changes over the years, out of which the four major amendments were in the years 2015, 2017, 2019 and now the latest amendment in 2020. The proposed amendments under the bill were based on the recommendations submitted by the Company Law Committee, which was formed with representatives from the industry chambers, professional institutes, and legal fraternity. The recommendations of the committee were largely based on recategorization of certain criminal compoundable offences into civil wrongs carrying civil liabilities, rationalization of penalties, mechanisms for reducing the overall pendency of disputes, and certain other ancillary changes to address emerging issues impacting the working of corporates in the country. The Company Amendment Bill 2020 got the assent of Honorable President as on September 28, 2020 to become an act and is thus operative since that date. It was passed by the Lok Sabha on September 19, 2020 and by the Rajya Sabha on September 22, 2020. The Amendment Act revolves around decriminalization of Companies Act 2013 and lightening rigor of penalties in case of defaults which can be determined objectively and which otherwise lack any element of fraud or do not involve larger public interests. Apart from decriminalization, the Amendment Act also provides for changes in the definition of listed company, CSR provisions, listing of securities abroad, periodical returns by unlisted companies, remuneration of independent directors and non-executive directors in the event of inadequacy of profits, etc., and has also introduced a chapter on producer companies. Some of the major key highlights and amendments of the Amendment Act 2020 are decriminalization of the Companies Act and changes to offences. The major thrust of the Amendment Act is its decriminalization. The Act has removed the imprisonment for various offences, substituted fine by penalty, and also reduced the amount of penalty payable in certain provisions. In case of certain minor omissions, penal consequences have also been omitted. More importantly, one-person companies, small companies, startup company or producer company or any of its officer in default or any other person in respect of such company shall be liable to only 50% of the penalty specified subject to a maximum of Rs 2 lakh in case of a company and Rs 1 lakh in case of an officer who is at default or any other person. Section 135, Corporate Social Responsibility. As per Companies Act 2013, a company with net worth, turnover or profits above a specified amount are required to constitute a CSR committee and spend 2% of their average net profits in the last 3 financial years towards the CSR policy. With the Amendment Act 2020, companies with a CSR liability of up to Rs 50 lakh a year have been exempted from setting up CSR committees. Furthermore, where the amount spent by the company towards CSR activities in a financial year is in excess to its CSR obligation, the company shall be allowed to set off the excess amount towards their CSR obligations in subsequent financial years. There is penalty for default and transfer of unspent amount to the respective funds on the company twice the amount required to be transferred or 1 crore whichever is lower, and on every officer in default of 1/10 of the amount required to be transferred in respective funds or Rs 2 lakh whichever is lower. There is no amount of a CSR committee where the amount required to be spent is less than Rs 50 lakhs, and the board of directors shall discharge the functions of that of a CSR committee. Exclusion from listed companies. The Act empowers the central government, in consultation with the Securities and Exchange Board of India, to exclude companies issuing specified classes of securities from the definition of a listed companies. The objective behind this amendment is to exclude such private companies that list their debt securities on a recognized stock exchange upon their allotment on private placement basis, thereby falling under the definition of a listed company under the Act. This has allowed private companies that only list its debt security on the stock market to avoid the requirement to comply with all the obligations of a listed company, such as filing of annual returns, maintenance of records, and appointment of auditors, which are quite onerous of a private limited company. Exemption from filing resolutions. The Act requires companies to file certain resolutions with the Registrar of Companies, which include resolutions of the Board of Directors of the company to borrow money or grant loans. However, banking companies are exempt from filing resolutions passed to grant loans or to provide guarantees or security for a loan. This exemption has been extended to registered non-banking financial companies and housing finance companies. Section 117. Resolutions and agreements to be filed. The Act requires filing of certain resolutions with the Registrar of Companies. It currently exempts banking companies which are providing loan, guarantee or security in connection with loan in its ordinary course of business from filing the resolution. The Amendment Act has now extended such exemption to registered non-banking financial companies and housing finance companies. Benches of the NCLAT. The Amendment Act provides for the establishment of benches of the National Company Law Appellate Tribunal, which shall ordinarily sit in New Delhi or such other places as may be notified. Listing of securities in foreign jurisdictions. One of the significant amendments of the Amendment Act is the empowerment of the central government to allow certain classes of public companies to list classes of securities in foreign jurisdictions. Section 62. Further issue of shares. Under Companies Act 2013, the time period for providing offer letter to the existing shareholders under rights issue process is 15 days to 30 days, beyond which the offer is deemed to be declined. The Amendment Act aims to reduce the timeline for applying for such rights issues and be less than the timelines currently prescribed so as to speed up such issues. Section 140. Removal, resignation of auditor and giving of special notice. As per Section 140, Subclause 3, if the auditor does not comply with the provisions of subsection 2, he or it shall be liable to a penalty of 50,000 rupees or an amount equal to the remuneration of the auditor, whichever is less, and in case of continuing failure, with further penalty of 500 rupees for each day after the first during which failure continues, subject to a maximum of 5 lakh rupees. It stands amended that in Section 140 of the Principal Act, in subsection 3, for the words 5 lakh rupees, the words 2 lakh rupees shall be substituted, and also maximum liability for an auditor has been reduced from rupees 5 lakh to rupees 2 lakh. Section 149. Remuneration to non-executive directors. The Companies Act 2013 makes special provisions for payment of remuneration to executive directors of a company if the company has inadequate or no profits in a year. The Amendment Act has extended this provision and has allowed payment of adequate remuneration to non-executive directors in case of inadequacy of profits, including independent directors. Section 129A, Periodic Financial Results for Unlisted Companies. The Amendment Act has inserted Section 129A, which empowers the central government to require classes of unlisted companies to prepare and file periodical financial results, complete the audit or limited review of such periodical financial results, and file a copy with the registrar of companies within 30 days of completion of the relevant period. Section 89, Beneficial Shareholding. Under the Companies Act 2013, if a person holds beneficial interest of at least 10% shares in a company or exercises significant influence or control over the company, he is required to make a declaration of his interest to the company. The Amendment Act enables the central government to exempt certain classes of persons from complying with the requirements of Section 89 relating to declaration of beneficial interest in shares. Producer companies. With the Amendment Act 2020 coming into place, a new chapter has been inserted relating to producer companies in similar lines to that of the Companies Act 1956. It includes companies which are engaged in the production, marketing and sale of agricultural produce and sale of produce from cottage industry. This chapter makes provisions in relation to incorporation and management of such companies, directors, conduction of general meeting, share capital criteria, and members' rights in relation thereto, loans to member and investments, merger and amalgamation, and penalties for contravention of the provisions. The changes and amendments brought in by the Amendment Act 2020 is a significant step in increasing competitiveness amongst companies incorporated in India and stimulating efficiency and growth while providing for ease in doing business to the corporates. We can say that the year 2020 has been a year of amendments to the corporate sector which will boost the working of the corporate and provide an easier environment to live and grow.